In recent years, it has become increasingly common for countries whose laws protect the lives of unborn children to be told by non-governmental organizations, by academics, and even by officials of the United Nations and of some foreign governments that they are obliged under international law to legalize abortion, at least in some circumstances. As Austin Ruse has discussed, the asserted human right to abortion, which is usually worded in some other way, for instance, as a right of access to reproductive health, has been grounded in the non-discrimination provisions of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. It has been grounded in the right to health. It has been grounded in an alleged right to privacy or to sexual autonomy, which is similar to the one announced in the United States Supreme Court decision in Roe v. Wade, and which is said to be implicit in provisions of various international treaties, international human rights treaties, and even, ironically and tragically, in the right to life that was recognized in the Universal Declaration of Human Rights and that is also a part of the International Covenant on Civil and Political Rights. Now, these efforts to remove resolution of the abortion question from the sphere of democratic choice are wrong and dangerous in several ways. Those of us in this room know that they are wrong on the merits, that if the unborn child is a human being, then the unborn child should be a subject of rights, and its destruction should never be the object of a right. But even to those who disagree with us on this issue, even if someone believes that there ought to be a right to abortion, that national laws ought to provide or protect a right to abortion, they must understand that we cannot simply turn all of our political opinions into international human rights. This does two things that are very dangerous, that endanger the whole human rights enterprise. First, it fractures the coalition which otherwise would support human rights. In many, many countries around the world, religious institutions, the Catholic Church, the other Christian churches, and other religious institutions have been among the primary promoters and protectors of human rights. And obviously, if they see that the object of the human rights enterprise is at least in part something that is very bad and that is fundamentally contrary to their principles, they're not going to be able to participate in those efforts, nor will individuals whose reason for supporting human rights is that they believe that we are endowed by our Creator with those rights. But secondly, it lends legitimacy to the arguments of authoritarian governments who have long argued that assertions of international human rights are just a gambit, a plaything of Western intellectuals who are generally on the left, and that they don't have to respect these human rights at all. In one of my jobs in the past, I was the staff director and chief counsel of something called the Subcommittee on International Operations and Human Rights in the U.S. Congress. And I used to say that my title, my business card, translated in most languages of the world into Staff Director and Chief Counsel, Subcommittee on Interference in Internal Affairs. And there are many governments who see all assertions of human rights, whether it's about the right not to be tortured, the right against extrajudicial executions, the right not to be imprisoned for your political and religious opinions. These are all seen as interference in internal affairs. And we legitimate that when we start just turning our most controversial political opinions into alleged international human rights, and with very little authority or logic asserting these as binding on governments. And yet, these efforts to assert an international right to abortion have been meeting with success. Austin has spoken of the Supreme Court decision in Colombia that invalidated that country's laws protecting unborn children on the ground that these laws were supposed to conflict with the country's international obligations. There was another Supreme Court decision in Mexico whose outcome was more confusing but where several of the justices relied on briefs by the Center for Reproductive Rights and other pro-abortion non-governmental organizations to say that there is an international obligation to provide access to abortion, at least in some circumstances. But often the efforts, the successful efforts, international efforts to get governments to change their abortion laws are not so transparent as they are in court cases. Very often it's simply quiet advice from an international advisor to a key government official saying, well, this isn't really up to you anymore. By ratifying these treaties, your government gave up its right to protect unborn children. And in these countries, typically these are developing countries that rely on donor states and rely on the United Nations agencies for crucial assistance in their health and legal systems. Although culture, tradition, and popular sentiment in these countries are often strongly pro-life, their governments sometimes lack the will and or the resources to respond effectively to arguments by these international experts that signing and ratifying international human rights treaties, by doing that, they've lost their discretion to protect unborn children from abortion. Now, we in the pro-life movement have vigorously opposed this, and yet we have found the old political rule, you can't beat somebody with nobody. You cannot beat something with nothing. Therefore, last year in March, a group of 29 experts in international law, medicine and public health, bioethics, and related fields gathered in San Jose, Costa Rica, to negotiate a document that would provide the governments and people of pro-life countries with the facts and arguments they need to respond to the false claim that there's an international right to abortion. The San Jose Articles were later signed by other experts in these fields, including a number of prominent people, some of them in this room today, some of them leaders of this Congress, and they were presented at a press conference at the United Nations on October 6th of last year. The articles, explanatory materials, and a list of signatories are available in English, Spanish, French, and 9 other languages at www.sanjosearticles.com. The San Jose Articles begin at the beginning by affirming that as a matter of scientific fact, a new human life begins at conception. This is Article 1. The first 3 articles and their explanatory appendices make clear that conception means fertilization, the first moment of the separate existence of a new individual, and that although there are various scientific terms for this individual at various stages of its existence, it has never been seriously questioned that the individual is human at each of these stages. Even the European Court of Human Rights, which has not generally been hospitable to the rights of unborn children, conceded in a case in 2004, and I quote, that it may be regarded as common ground between states that the embryo, fetus, belongs to the human race. Now, having established that the unborn child is a human being, the Articles marshal international legal authorities for the proposition that all human beings, as members of the human family, are entitled to recognition of their inherent dignity and to protection of their inalienable human rights. That is Article 4 of the Articles. They make clear, and this is such a crucial point, that a state party's obligations under a treaty are limited to what the states that negotiated and ratified the treaty knew or should have known they were agreeing to. When all of these human rights treaties were agreed to, almost every state in the world, the exception primarily of the communist states in those days, protected unborn children almost all of the time or all of the time from abortion. And there was no evidence that this was just a leftover legacy from some previous age. These laws were and are vital. And the Articles also make clear that treaty monitoring bodies such as the CEDAW Committee have no power to impose new obligations on states parties. On the contrary, the Articles suggest that states may and should invoke treaty provisions guaranteeing the right to life as encompassing a state responsibility to protect the unborn child from abortion. Finally, the San Jose Articles urge governments and members of society to ensure that national laws and policies protect the human right to life from conception. They add that governments and citizens should also reject and condemn pressures to adopt laws that legalize or depenalize abortion, and that donor states, United Nations bodies and officials, and others should refrain from these pressures. Rather, international maternal and child health care funding and programs, in the words of Article 9, should ensure a healthy outcome of pregnancy for both mother and child, and should help mothers welcome new life in all circumstances. The laws of about 2/3 of the countries in the world still protect unborn children from abortion in all or almost all circumstances. The San Jose Articles can be an effective tool both to enable pro-life citizens and government officials to resist pressures to reduce or eliminate these legal protections and to inform a wider audience about the true state of international law with respect to abortion. But they will only be that tool if those of us in this room and others like us use that tool. So I urge you to go to www.sanjosearticles.com. No punctuation there. You can check with the excellent secretariat of this conference for the spelling of San Jose if you need to. And please learn those articles and use their explanatory materials. They are useful. They make a persuasive case that states still have both the right and the obligation to afford legal protection to the most vulnerable members of their societies. Thank you.